going to take first a little info, which is driving me crazy. She doesn't know what it is. And it's about the topic that we're here to touch on today. And this goes back for me decades when I was a law clerk. And I don't have a technical background, and we had patent cases come in. And we would really do our best to understand the technology. And there was one case that was not my case, it was my co-clerk's case. And it had something to do with eyes and contact lenses, and there was eyeballs sitting all around chambers. And I had some recollection of this, but it wasn't my case. I didn't think much about it. So fast forward 5 years, and I'm at a event, and I'm at an AIPLA dinner, and there are lawyers across the table from me, and we figure out that they were the lawyers on this contact lens case. And he says to me, the judges see how you react to this, with all due respect, it's not going to be respectful, with all due respect, the Ferguson just didn't get it. And what I didn't say out loud to that was, and that is on you, right? That is not on Judge Ferguson. He tried his absolute best to understand things, as did us in the first. That is 100% on the lawyers presenting the case. And so this is called storytelling in IP litigation, which is fun. It's fun to have stories. It's fun to tell the story of the case. But the second half of the title is also really important, which is how to explain complex technical issues to judges and juries. So I know we're going to hear a lot about that as well. And I think that's really important, and that's a both of making sure that you understood. Just so everybody knows, Paul Grayball is on his way. He was stuck in traffic like many of us were on the way here today, so we're giving him a little bit of time. So in the meantime, I am going to tell you a fun fact about each podcast because they are already known to you generally. So I thought rather than give the whole title. And then if Paul's still not here, Nikki is going to do a kind favor.
I'm going to channel Paul. I used to work with him.
Yes.
Sorry.
Okay, so starting with Judge Freeman, which you have the least fun. I'm so sorry. Mine was that, but she had been. I didn't realize that you were nominated in 2014 and confirmed in just over a month.
No,
That's
I had to be re-nominated because my nomination expired at the end of the year. So no, there's nothing special there.
Was re-nominated. But I also heard that in 10 years, like when you took the bench, you said, don't know about these patent cases. And now you are probably one of the judges in the country that has had the most patent cases that you've heard. No, I mean, what? Judge Van Buren. What everyone should know about her is she was an IP litigator before she took the bench. So she will have no mercy if you're not applying your judgment at all. She also is on the committee or was on the committee before taking the bench that worked on the patent rules. So we have her to think that I do mean that we should think because without the patent rules, things let them up. I'll tell you that cases in other parts of the country. Judge Cobb. He doesn't seem like he was an IP lawyer. Turns out he has an industrial engineering degree, so he's a secret scientist underneath. Paul Grayball too. I'm jumping ahead to him. He went to MIT and had a degree in environmental engineering to do that. And then Nikki, thank you so much for stepping in. Nico is the general counsel of not general counsel. I'm promoting you.
Not the general counsel.
Right?
Yes.
And she says that she did not have a technical degree, but she convinced Paul that she was a patent lawyer and he had her for her position. So with that, I will turn it over to you.
Thank you so much, Jennifer, and thank you so much to everyone for being here. I'm very honored to be a part of this panel. So thank you to our judges, our amazing judges in advance for their time. I will start by just asking, I know that you all have had fantastic careers as litigators and trial lawyers, and also have sat through and have presided over a number of patent cases. I'll just ask you the general question, what makes a great trial lawyer, like really great at what they do? I would love to hear just your observations, just canvassing the number of cases that you presided over.
Con, you want to start?
Okay, I don't know about great, but the best trial lawyers I've seen are, uniquely themselves and, extraordinarily comfortable in the courtroom. And they speak conversationally for the most part, and to the jury especially, and, they try to come across it as, not, not to avoid it, put it on kind of act.
Well, I certainly agree with that. I think that the great trial lawyers that I see show humility to the jury. They work hard to communicate with the jury. They know who their jurors are. I mean, here in San Jose, they may all be PhD engineers. It's hard to say. But they are able to really take the jury where they are and talk to them and communicate with them.
Yeah, I would, of course, echo all of those things and, bringing us to our theme today. I think, the most effective lawyers I see in the courtroom, especially in our complex technology cases, can start, at a very basic level. And they can take, no matter the technology, and relate it to something that everybody in the courtroom can understand and knows what it is. I think one of the best examples was on a tutorial I was running, and the lawyer reached in her pocket and pulled out, well, the case was about, complex storage components and moving electricity around, if you will. She reached in her pocket and pulled out a battery. Because everybody can immediately relate to that. And then work from there to the technology. And I think that technique, it brings people in, they're instantly comfortable. Okay, I don't have to be afraid of that. I know that battery, I've got it in the drawer at home, and then build from there.
I would love to ask you about just storytelling in technical cases. I think I clerked for a judge in San Diego, and he told me, Nikki, you cannot win an IP case or a technical case without a compelling overarching story that will enthrall the jury. So I would love to just hear from your perspective. Is that true? What if you just don't have a compelling story to tell on behalf of your client? What do you do, and what makes a compelling story?
So I think every case tells a story. And I don't think that IP litigation is different than any other litigation. The jury has to know why they should feel that your client is in the right. So in an IP case, you have an inventor. You have a company that started from the ground and worked its way up. You have in pharma, your company may have saved hundreds of thousands or millions of lives. There are stories behind the technology. The claim elements are not your story. So, but there are people. There is a David and Goliath aspect to so many technology cases. And, you have to wear the Goliath lightly and explain why you're not the bad guy. And if you're the David, you can wear that proudly. But your CEO can tell the story. I have had many cases where it was the CEO who riveted the jury because that was the person who made it all happen.
I'll totally echo that. So, in preparation for a jury trial many years ago, we did some mock jury exercises, and because it was a mock jury, we didn't go through everything, of course. And one of the things we gave relatively short shrift on was kind of we were acquainted the history of the company and the history of the invention and all that. And there were actually multiple mock juries. One of the mock juries had a piece of prior art. Somebody looked at the author of the piece of prior art, saw that, the bio at the bottom, that they were associated with some company in Sunnyvale. And our client and our vendors back in the day their headquarters were in Sunnyvale. And that mock jury, because it was no story, that mock jury went off on this wild speculative story. They invented one themselves, that somehow our inventor had stolen the invention from this prior author because they were both in Sunnyvale around the same time. Right. So the lesson learned, because it was mock, was we spent a lot of time with that actually the inventor had passed, so we had the co-inventor. We spent a lot of time prepping for the jury trial with our inventor to testify, and he told a very compelling story about a Silicon Valley startup. It started with three guys, literally, but the startup in the garage. And they worked, they scraped by with no VC money for about a year or two, finally got their first, and, we told that whole story, and it was a huge Silicon Valley success story, and he's a very compelling, very, very nice guy, right? And the jury loved him, right? And I don't know, I mean, we didn't figure out why we won, but that clearly, that jury, the real jury, did not spin off into some conspiracy theory that our inventors had stolen the invention of something in prior articles, because they found the place out. So telling the story, I think, effectively
Yeah.
is really, really important. And as Judge Freeman said, having the right person tell the story.
Well, and I'll also comment, every once in a while, the origin story is more myth than story. So let's make sure that you get it right so that it's not subject to cross-examination, because then credibility would be lost.
Now I'll go to a much harder example, which is when you represent the non-practicing entity. And, some of those cases do get tried. And, finding a compelling story in that context, is a challenge. And I've seen it done. I've seen it done very poorly a number of times, because it is very hard to mine that, and see what you can find. Now, if you have access to an inventor, that changes. But if you don't, I've seen it done well in terms of, really talking about the patent and the grant of the patent and the rights and, kind of embedding yourself, wrapping yourself up in the Constitution. But you, sort of have to navigate that. And it's just admittedly hard. I don't have any secrets for that one, that's for sure.
Yeah, with the non-practicing entity, getting the inventor in may be difficult. Sometimes you get the inventor who was with the university and then they took the patent with them through some arrangement. And so you've got someone. When I first started hearing patent cases, it was regular that the inventor would testify. But then I heard a few trials where all of a sudden I learned the relationship between the company and the inventor wasn't so good anymore. And so it was hard to control the inventor. And I think that's why I started seeing fewer inventors come to court.
Hi, Paul, welcome. We were just talking about.
Well, that was my job.
storytelling.
Help that I worked late, I apologize to you all.
We were just talking about great storytelling and how you need a compelling narrative in order to just enthrall the jury and to pull the jury in and to get them to root for you and your client. And I would love to hear, I know that when you were on the bench and with the trial litigator for a number of years, how did you come, when you represent the Facebook or the Meta of the world and the Google of the world, how do you come up with a compelling narrative when you are sort of the Goliath against the David?
Yeah, well, I think relative posturing and relative power of the parties can impact your ability to tell that story, at least in a convincing way. There are also just constraints that you face representing a large organization with executives, including founders, who are often quite constrained in terms of time and commitment and ability to focus on any one case when they may have several hundred cases pending in federal courts every day. But I think that the founder story is important. If it's not available, the alternative, I think, is what I call the arc of the hero narrative, which is that even if you can't tell the story, the day that Larry and Sergey, first came up with the idea for the search algorithm, or Mark had the spark of genius as to how to build a social media app. What I think you can tell is the story of how the company has grown, what it has accomplished, and not just talk in terms of success, because I think success is a complicated theme in our culture today, but how it actually has impacted real people and made a real difference in ways that were meaningful to not just the jury, but even.
Well, I'm happy to continue to.
You're doing a great job.
Well, I will turn it over to you. I'm trying to channel Paul, and I said that we worked together for a number of years, and so.
Sounds like you're So I actually, wanted to start with that overarching point. But I also wanted to dig in a little bit and ask the judges and you, Nikki, as well, about how you use that narrative or storytelling at different phases of the litigation, because I think we all reasonably focus on what this means to the jury in the box at the conclusion of the proceedings. When you first had to confront the technology, Karina, I'm looking at you, so maybe I'll start with you. At the claim construction stage, even at the technology tutorial stage, does storytelling matter to you at that point? Or are you really just trying to get down to brass tacks on what the claims mean, what the terms, how to be construed as?
So I think that sort of the technical storytelling can be very effective to the judge. We are trying to wrap our minds around what this technology is and why the patent should be construed, if the claim should be construed in a certain way, and trying to size up the lawyers on both sides. So I think that story matters. I think that, there are ways to, in a serious way, more serious than in front of a jury, although it's serious, it's just at a higher level before the judge, to really introduce the judge to your company and to understand what that company is and does. Because at the end of the day, we're all persuaded by the same sorts of things. I always think in terms of the story, and that you can't separate that from the storyteller. So I think we'll get to that in a minute. I won't tread on that yet.
Well, in that vein, is it helpful to any of you to start with the history of the organization, whether it's the patent holder or the defendant? Do you mind, or should lawyers standing before you inquire or ask it straight up? Like, what do you want to hear about, Judge? I think for a lot of lawyers in the room, and certainly for their clients, the goal is always to give the judge what she wants, right? And so I'm curious, like, do you often field questions from lawyers about whether, you want to hear some of that origin story or narrative as they enter the courtroom to talk about claim terms, or is there a problem with they ask?
I think it can come up best in the tutorial. Because then we're all kind of off the record, it's early in the case, we're trying to learn about it. I think that's probably a good entree for the judge.
Judge McKeown, I want to ask you, now we've had a number of reps on you, a number of years on the bench, the great bench, by the way. What do tutorials like factor into how you resolve discovery disputes or other pretrial issues?
Definitely, and, kind of to your point a moment ago, of so much of these discussions often focus on relating to the jury. And there's a lot that happens before you're in front of a jury. And even before you get to Markman, and that's the whole, you may have a series of discovery disputes, you may have fights over your infringement contentions or your invalidity contentions, which here in San Jose come to the magistrate judges. And so, I think that, you need to not overlook those opportunities. I know, when I first came on the bench, certainly in my patent cases and more complex technology cases, I would calendar and try to go to the tutorial, but sometimes the tutorials are late. Some of the judges like to do them close to Markman. And so actually what I typically do is if I have a case come in with a discovery dispute, if I want a short tutorial, I let the parties know in advance so they can prepare. I give them some guidelines. I mean short, maybe it's 15 minutes aside. So I don't need the whole history of the company at that point. But I want to know, I don't want the PhD dissertation. I don't have time for that. And I probably don't need it for the discovery dispute in front of me. But I want to know, starting basically, tell me what this is. And anyone here can describe, present company accepted, a blockchain in plain language, you'll be first up. But that's, I ask for a short tutorial and I give the parties guidance. I welcome demonstratives. They have to share them. It's often early in the case and parties sometimes are a little reticent, but they have to be able to explain what the technology is and support or argue against outstanding discovery requests.
We often focus so much on trying to figure out the what and the how in explaining technology. One question we don't talk enough about, I think, is the And I'm curious, just comment on this question. Do you have a preference on who tells that story to you? Do you care whether it's the lead trial counsel, whether it's an associate, whether it's an expert, whether it's a technical person, a lay person? How do you?
I don't use, the title is not the criteria I use. I think I want the person who is best able to explain it, and that may be the first year assistant. Right? And I think it's typically, in my case, probably more helpful if it's an attorney as opposed to an expert. But again, it's a tutorial of any kind or anything that's really, even in discovery hearings, we're not really going to the merits of the case. We're just trying to get educated. I'll hear from almost anyone as long as they're the right person to talk about the technology and answer questions.
Judge McKeown mentioned demonstratives. Do you typically receive demonstratives? Are they helpful? Are they useful beyond the hearing itself?
They're usually, for me, especially like discovery disputes, they're not that useful beyond the hearing. So I will say where, and I like what Judge McKeown said, where the understand the technology and the products development helps me is understand disputes over scope of discovery. So like how many custodians and who those custodians should be. That's often a hotly litigated discovery issue. And if I have a better sense of how the company is actually developing its product, is some understanding of how software is made, but each company organizes their teams differently, right? And so understanding how they split up the functions and all that. And if it's an industry that I don't have experience with, like pharma is not way outside my personal relevant experience, it's really helpful to understand that kind of the story of development in that sense, to put it all in context.
So there's well, can I ask the other, there's any thoughts about who ought to present the story?
So,
Story.
it's no different than a jury, the person who can best communicate. And I find that lawyers are usually better at that than the experts. And I'll give you an example. Early in my tenure here on the bench, I had, the lawyers came in with their expert to give me the tutorial. And the expert started by saying, Judge Freeman, in the next half hour, I'm going to give you a college level course in physics. And the little bubble over my head was saying, does he know I didn't take physics in high school? And this was a college professor and he thought he was he probably thought he was dumbing it down already, but we had to be even lower. The lawyers, most of the trial lawyers are not the technical people. And so the ability to communicate is enhanced because they've had to learn it themselves.
Yeah, the instruction I get a lot of my outside counsel now as they prepare presentations is think less, professor and more like Khan Academy. So
Yeah.
if you can get it to that level where maybe informed by your technical prowess, but not dependent on it, I think you're doing the right thing. Was one other question on who should do the presentation. Have you ever seen a technical tutorial, a story told about the history of the invention, presented well when it's told by more than one lawyer, or more than one person? There's something.
I have.
Have you?
Yeah.
Well,
Yeah,
can you-
but only, I mean, I think it was split, but it was sort of more narrative and then more kind of drill down technical, and it worked. It worked, and I don't mind that.
Maybe if your outside counsel maybe had said, we'd love to split the technology tutorial, would you ever say yes?
No. I think in part because we really try to use the tutorial as an opportunity to really educate the court and the law court about the technology at issue. And I find that works well when you are able to reach out to the other side and agree on a joint tutorial together. So you can just, it's not argumentative. It really is just like, the landscape of the technology at issue. And I think that is probably pretty beneficial to the court. We usually sometimes we'll put together pre-recorded videotapes of the tutorial and submit it to the court. And so in that case, we'll work together with our expert on the transcript. So, we'll retain like a TV friendly voice to kind of narrate the tutorial. I think if it is a live tutorial in court, we usually prefer our lead counsel or outside counsel to handle rather than our expert.
Well, the advantage of lead counsel is the judge is getting to know you. And so if it's a parade of different lawyers throughout the case, we don't develop that relationship. I will say that one problem I see with tutorials is that they are too simplified. And then when I get to claims construction, I haven't learned about the technical part of these terms enough. And so I don't need to know how batteries work. I need to know what this invention is. And so that's a hard thing. And it may be that you just really got to think about ramping it up during the tutorial of starting simple, but getting to what the crux of these issues are going to be.
And let me just echo that because I think the stepped approach in communicating your technology is really important. And maybe you go through all the steps in the tutorial, but also different steps at different phases of the case. And the very basic, elevator speech, what is this? Is where you start, and you may never use it, you may need to use it, you may need to use it on your first discovery dispute. And then sort of what I think of as the dinner table conversation, where you can talk about it, you've got the right vocabulary, and you can exchange some back and forth. And then there's the college level course that you probably need at points for claim construction and your infringement argument in front of the jury. But also, I think juries, lay people, and certainly I would include myself in this. I appreciate if I'm being told, look, we're gonna start here and go here, and later if needed, we'll go here. I appreciate that. Then I get, okay, maybe they're holding back something on the technology, and I know there's another step. But maybe I don't need to go there, and I'd rather not sit through the college physics course.
If you haven't seen it, there's a great meme that you'll sometimes see on the internet, where they'll present a subject for you. You brought up blockchain, and they'll have in like 15 or 30-second clips an explanation of what that is to a first grader, to a 12th grader, to someone in college, and someone getting a PhD. And it's a really interesting progression. But I think after the idea, yeah. One last question on the who. This is really for anyone. It's appropriate we're sitting under the portrait of Lake Ron White. One of my strongest memories in this courthouse was when Judge White was the district judge presiding for a case, which I was assigned as the magistrate judge. And he invited me to sit in on his tutorial with him. So the two of us sat out there, and I tried my best to keep my mouth shut, and Judge White did the talking. Would it ever be helpful in a case where magistrate and district judges are both assigned to the matter to have a joint session, particularly on technology? Doesn't he consider the appropriate matter?
Well, Judge Angelini and I've done that. She often has sat in on my tutorials. Yeah,
It works, right?
yeah, I mean, not both on the bench though, I never thought
No,
about
no,
that,
no.
but,
It's important.
yeah, but in the courtroom, and I think that's been great.
Okay, yeah, it's been invaluable. It gets harder for scheduling purposes,
It's
but,
been-
yeah. it worked.
Well, let me move on to another phase of litigation, the discovery disputes that often are part and parcel of any good IP fight. When resolving an issue over custodians or an issue regarding over response to an interrogatory, are any of you particularly interested in any narrative at that point in the case, or are you really just given the volume of matters on your docket that day, and you need to just call a certain ball or strike, you just focused on getting to the answer of custodian number 16 necessary, but one to get. Or do you want to hear some stories at that point? There's conflict.
I'll say, I mean, it's up to the lawyer presenting their arguments, but I think, if it's a dispute about the custodians and there's a story to tell, you're doing yourself a disservice by not telling, it's not just 15 versus 16 custodians, it's we've already identified and agreed that we're gonna put everyone in the Seattle technical team in the custodian list, but they want to add everybody in Boise, and people in Boise don't do anything that's relevant to this case. I mean, that's a much better argument than 16 is worse than 15, right? And so I do think there is an opportunity in regular e-discovery disputes to tell that story. Same thing goes with search terms, right? I mean, people say, well, we proposed 3,000 search terms, right? And the other side will only do 2, right? Well, okay, so 3,000 is worse than 2, 2 is worse, okay, that gives me a number, but if you tell a story, say like these 8 terms go directly to, antibodies, the antibodies we're talking about. That's what they're variations on the antibody, right? But they propose these 30 terms that are just general terms in the pharmaceutical industry, right? That's it, again, there's a story to be told, there, right? And so I do think there's room, I was talking to the baby lawyer, there's room even in discovery disputes to tell a story and to, you know, to try to figure out ways to humanize the dispute.
Judgment killing, what do you think?
Well, I think that that same logic applies, even if you're talking about scope of interrogatories or scope of RFPs, right? Is, okay, you're saying something is too broad. Well, why? Besides, I don't like it, it's gonna be too expensive, it's burdensome, it's, okay, but why is it not relevant? Why is it not proportional? You know, the language, the useful language for and against, the scope and discovery is right there in Rule 26. So, you know, tell me why, you need more or more is not proportional to the needs of the case. I'm listening, tell me,
Yeah, the why matters too.
the why.
Well, I actually want to just circle back to one point that Freedom you made earlier, because I think it doesn't get brought up often enough. I want to draw a line under it. You mentioned the opportunity to begin to build a relationship with lead trial counsel that you may not be as familiar with. I think sometimes in bench bar conversations, that attempt to build rapport is viewed as sort of something you don't acknowledge, you know, openly, or is viewed as sort of underhanded or tricky. But I don't think that's true at all, right?
I'm not going to be your friend, that's not what I meant.
But you are trying to establish a dynamic of some.
So especially in complex cases, I need to know who I can trust. And yes, I can read every case citation you give me and decide whether you cited it right, but sometimes that takes too long. But, you know, I've had cases where in the first couple of hearings, the very charismatic, powerful lawyer just grabs me. And the other lawyer may just have a more humble approach and not really assert himself. And over time, I found myself sort of discarding that what becomes a blowhard who's just got this, you know, he's on all the time, and realizing that this other person is far more solid and far more trustworthy. And if that person says something, I can be pretty sure it's fairly stated. I may still disagree. That's not what I'm talking about. But can I rely on your representation? So that's where the report comes in.
I think it's critical, and I think that in many ways, establishing or building that rapport through the story, validating that the storytelling at the beginning of the case proves to be the correct one, or the accurate for the life of the case is so important.
And then there are the cases where different law firms cycle in and out. And I see a lot of patent cases. Of course, I'm never privy to why, but there aren't that many reasons why you fire your lawyer, I figure. And so you know, I can't ask and you're not telling me, and there we are. And all of a sudden I'm starting over again with a whole different trial team and wondering what went wrong.
Yeah, Nikki, as you're thinking about what outside lawyers you want to have represent you and your company, is that ability to establish that before something that's added to the top of the list? Is it is it a nice to have, so a must have?
I think it is a must have, and we need our outside counsel to have credibility with the court. We try not to terminate or fire any of our lawyers, in part because we really value the relationship. And I think that especially for more, you know, the significant higher risk cases, you want trial counsel. So you want to retain trial counsel from the get-go on day one, so that you can sort of have a more, you know, robust plan for how to try the case and start developing themes and narratives and pruning the case for trial. I do think that a great trial lawyer is someone, I think, at the end of the day, for trial purposes, can really say, I can sell this argument to the jury, but all of these other arguments, they may be the best argument from the technical perspective. And if we try this case with the ITC, those are going to be my top argument, but not to the jury. And I think that the judgment and just the instinct that, like, you need to really prune and trim down the case to the bare basics is, I think, what really great trial lawyers are good at. But absolutely, credibility with the court and just having a rapport and credibility with the jury is really important, because I think jurors just, a lot of the time, it is really difficult. When I was clerking in San Diego, there was one case where when the judge talked to the jury afterward, they were really frustrated. They basically told the judge, everybody in the courtroom were more capable than us at answering these questions. Why do you want us to do it? Literally, we're more capable, all of the lawyers in the courtroom are more capable. Your courtroom clerks are more capable than us at answering these questions. So I think jurors really try their best, but at the end of the day, some of the cases are so technical that it is really difficult for them to digest the information and to understand what's going on. So I think credibility is really
I
important.
do think that to come back to Freeman's thought bubbles, that I'm sure form over your head every hearing and every trial. When you're wondering about, perhaps why the counsel are appearing before you, it's not necessarily always the case. And the true explanation most of the time. But sometimes, we will switch out counsel when it's obvious after the first hearing, or maybe the first or second hearing, that their ability to tell an accurate and compelling story isn't landing with this particular judge.
Right, so there are many reasons why I get new lawyers cycling into a case. So some lawyers end up firing their client. And you may all have had that situation where you have a long talk with your firm about how you can no longer go on to represent this client. It happens. The other thing, in terms of developing a rapport, I don't mean to suggest that only the senior lawyers should come into court. What I'm really saying is bring those junior people in from the beginning and develop the rapport, because otherwise the newer lawyers on your teams will never have the opportunity to be in court. And I will tell you, the jury wants to see the younger lawyers. I had a very complicated patent trial a number of years ago, and the presiding juror was a Stanford University junior. I'm not even sure that she was of drinking age, but she was of voting age.
Right.
So, if you only have the very senior people there to present the case, that may not resonate with that juror. So bring them in early and don't keep them out.
This is a really good point, because you have to set them up for success.
Yeah.
Right, and one way to do it, maybe the only way to do it, is to make sure that they're part of that team, that important see. Well, let's move on, let's move forward towards, summary judgment. Almost always, it seems like in your complicated IP cases, or really any IP case, you're gonna see summary judgment. Anybody had an IP case where nobody filed a summary judgment? There you go. There you go. Now, the task and the challenge, and of course, summary judgment, is to evaluate the record and see what evidence has been marshaled in aid of the story. I'd love to just get your impressions about how you approach oral argument in summary judgment, and the extent to which you'd love to see the lawyers spend those precious pages you give them to brief the issues on framing the dispute in a broader narrative. Judge Conway, I'll start with you and everybody else.
So I've only been on the bench a year and 4 weeks, so I haven't seen a lot of summary judgment. But, so I'm speaking more from personal experience as outside counsel. Summary judgment is, if you lose, you're gonna go to trial. So it's your chance to start, if you haven't spent the earlier part of the case really starting to set the table for the judge on what the story is, and kind of give them a preview of what the case is really about in that larger context. This is your chance. You better do that summary judgment, because you're not. I can't. I mean, there's no other real good briefing opportunity to convey that story to the court. So absolutely. And yes, it's precious pages in the summary judgment brief, but I think we just. I've seen it in other motions, but I've seen it in motion practice. I don't need a whole page on the legal standard for the motion to dismiss.
You got the rules, yeah.
Right. And and so there are ways to, there's a judge, there are ways to, make space for that story. You can tell the story in a paragraph. You don't need to spend 5 pages on the story.
Different, what do you think?
So the biggest mistake I see in summary judgment is that it's actually the cat and dog arguments that come in and not the real ones. So yes, summary judgment is good for trimming the issues to be tried. So often willfulness is right up there. And there are other issues, and maybe it has to do with something with the dates that are important that can really make a big difference and simplify the trial. But then I get all kinds of things. I did one just recently where there was a 101 argument and the paragraph was this big. And I thought, and you know, I mean, I think we probably said a little more than this, but essentially that's denied because of inadequate briefing. So it's a waste. That's what I find is that lawyers are afraid to leave an issue out for lots of reasons. And yet you harm your persuasiveness on the good issues that you have. Not every case should have cross motions for summary judgment. And yet that's typically what I get. And I think there's a feeling that if, as a plaintiff, there's really not a lot that you can persuasively do. Maybe some of the defenses against you can try to knock out, but I think there are a lot of missed opportunities in the summary judgment. You get to set the table for us, but you're trying to persuade.
It's kind of funny, right? Think about like what a hash the Federal Circuit Supreme Court made of Section 101, the idea that you could summarize it like that. Somebody must have thought that's kind of a fair, right?
Yes, or, yeah.
Someone must have thought they were writing a J-mall.
Yeah, they're making their record,
That
but.
they can just like,
It
oh, you can-
relates to something Nikki said about, you know, the good lawyer who will tear down their presentation in a court, and the same thing applies in briefing. For summary judgment, I'm gonna put Daubert in this discussion too, because, both summary judgment and Daubert, seem to have, I think, moved into sort of the mutual assured destruction mode. But we're both going to bring them, and we're gonna bring however many the other side is bringing, because we have to.
Yes.
And I wish we could get counsel to step back and have heart to heart with client, about what's the value add? What is the value in this motion? Willfulness, you may have a good statement of law and there may be no evidence in the record to support it. That should come in, absolutely,
Yeah.
because then you're locking stuff off cases. But when you're fighting and you're part of the summary judgment motion and supported by, you know, declarations and deposition testimony, and, you know, I get exhibit binders like this, and the other side in opposition, the exhibit binders like this. Gee, you think there's a disputed fact in here somewhere? Probably,
I'm
and
very
frankly, I don't really wanna go look for it.
I was gonna say that I'm usually very negative when it comes to summary judgment motion. I will, you know, the Bob Bennett and the Jeff Loomish of the world will be Nikki, I think you can move with them. I was like, we can't move on to on summary judgment. No case, this particular judge has never been to summary judgment on this specific issue. There is a factual issue here. And so I think if we really apply the standard correctly, it is relatively easy to defeat a summary judgment motion. And so I think especially from the client's perspective, I think you have to be really judicious about the motions. And I actually, you know, Judge also, a number of judges will have the one summary judgment rule, which I think is really fantastic. And a lot of judges will put page limits as well. I have never thought that on a motion, that we would have won a motion if we had more pages. I think that shorter is always better. And, yeah, and I am usually skeptical that we can win summary judgment motion, but I agree that Wolverine is probably the one issue that is.
This is a great example, I think, of a topic, that clients and counsel talk about, that I don't know that the judges always have a chance to hear about. So I want to explore this a bit more. Judge Conn, your insights in this may be fading fast, so hopefully it's. Maybe I'm just curious, could you just maybe share for the judges benefit, for all our benefit, how you work, like, what's the dynamic like with your outside counsel on deciding what issues to bring, how to allocate, you know, pages, what issues to drop? Like, what's that conversation like? And obviously, you're the client, so you're making the final call, but how do you work with outside counsel to the right answer?
I think we usually start with just a brainstorming session of what issues we think we should consider moving up on the judgment for. And then we get an outline, and I will have a conversation with lead trial counsel, because lead trial counsel at the end of the day has to like own the decision and also have to make a recommendation to us as to whether, you know, the likelihood of success of a particular motion. I usually don't like to try to bring a motion that we know that we're not going to win for the purpose of like I don't know, trying to get, the other side's response on a particular question or trying. I think, to the extent that we want to educate the court, I think there are a number of different ways to do that. You can do that during, motions to eliminate. If you have a compelling Talbot motion, I think that there is an opportunity to educate the court as well. The pre-trial papers are really, great opportunity to educate the court. I, at the end of the day, don't want to waste the court's time because I think that, those summary judgment motions are really expensive, time consuming, and it doesn't make sense to bring a motion that is, at the end of the day, just objectively speaking, you think that it's a loser and that it's not going to get you out of the case or significantly narrow the case.
What you're describing is collaboration. One way that I've often thought about sort of balance between the role of the client and the role of outside counsel and collaborating on such a tactical call on what to file and when is that as you start a case, I think ultimately it really is the client's case. We have a dispute and we reach out typically to outside counsel when we want to retain someone to represent us. And at that stage, it's largely our conception of what the matter is and how we want to pursue this for strategic purposes. Over the life of a case, though, especially as you move towards trial, I think this is where the trial counsel's expertise and in particular, their credibility and their rapport in relation to the judge starts to weigh more and more on decisions that are going to impact what gets presented in what order and so on and so forth. But it's a very interesting dynamic. It does change over the life of the case, right?
Yeah, absolutely. And I really do think that the client owns, the decision in the case at the end of the day. We rely on counsel and we often get recommendations from our outside counsel as to, what to do in terms of, strategic calls. But whether or not to bring a summary judgment motion on any of the issues in the case, I think is ultimately a case that you as the owner of the case have to make a recommendation on to the leadership of our company. And so I take ownership of the case. And so I very much feel comfortable, pushing back against recommendations that I think is not meritorious or doesn't make sense. Because I don't think you can defer to outside counsel. I mean, if you lose a motion or if we have to go to trial, it really is a decision that was made by you.
Yeah, it's funny, the board doesn't call outside counsel.
No?
So, no, I think, the way I've often summarized is outside counsel makes recommendations, ultimately, sometimes very informed, always informed, but sometimes very heartfelt and strong recommendations. The client makes the decision.
Yeah, and usually before we go to trial, I will make sure that the leadership team sort of understands the potential consequences of trial. Because I think regardless of how good you feel about your defenses, I think trials at the end of the day could be unpredictable. And so I want to make sure that folks understand just the scope of our damages exposure, including willfulness, including the potential for an ongoing royalty. And I think getting folks to understand that if we go to trial and if we jump that, or you understand the damages could be hundreds of millions of dollars, and we have to be comfortable with that. And we have to be comfortable with appealing that decision and living with that verdict for a number of years before we may be able to get some.
I'm excited to get to trial too, but before we get to trial, I want to ask the judges about maybe the next and last step before trial, where telling the story matters. For you. Let me ask you how you think about voir dire, and lawyers always want to have more of an opportunity to inform the jury, they put it, about their case during jury selection. How do you approach this?
Well, voir dire is not the time to tell the story. It is not the time, I call it preconditioning the jury, and I don't allow it. It is, but that said, I have a great respect for the effect that a lawyer can have in helping find the right jury for a case. So in my cases, I like a lengthy questionnaire that the lawyers write, and I work with them on it. That goes to all the jurors, and I don't ask questions at voir dire. I let the lawyers do it. Over all the years I've been presiding over cases, it's become my firm belief that jurors are more honest and candid to lawyers than they are to judges. The jurors always like the judge, you all know that. the jurors want to please the judge, and the jurors are looking to come up with the answer they think the judge wants to hear. So can you be fair? Oh, yes, Judge, I can be fair. When you ask the question, so, what do you think in terms of fair? How, a scale of 1 to 10? And the lawyers get a better answer than I do.
A shocking percentage of perspectives will answer, oh, about 2, maybe.
Yeah,
No more than, no more than.
Right.
They'll never tell you that.
They would not tell me because they know I don't want to hear it. Yeah. I mean, I could rehabilitate any juror, so I try not to, because that's not going to help us.
You brought up the questionnaire, which I just think is just a remarkably more efficient way to solicit information than the whole exercise that we traditionally go through. In that voir dire questionnaire, do you allow the lawyers to stray a bit from the basics of, bias or knowledge of the facts, and like to at least get the jurors' impressions of potential themes or potential impressions of themes and narratives? Like, are you really?
So that's a hard one, because in my view, first of all, even though the lawyers are writing the questionnaire, it's my questionnaire. I am the one giving it to the jury. And I am only interested in excusing jurors for cause. I couldn't care less about your peremptory challenges. So I know that a lot of the questions are written because the jury consultants have said, this question will help us find out if someone is, has a way of looking at things that's not favorable to us, but it wouldn't be biased. So I don't let them stray too far. And there are some questions that out of context invite the wrong answer. So in a criminal case, for example, lawyers like to put in, all the constitutional questions. Can you, if the defendant doesn't testify, will you hold it against him? Well, of course they're gonna hold it against him because they don't know that's the Constitution. And so I don't let those questions be asked because I want the jurors in the courtroom. I want to talk to them about the Constitution, and I want to remind them that, these are your rights and my rights and Mr. Defendant's rights here. So, in patent cases, it can be the same thing, is that the question out of context is going to bring out an answer that the juror doesn't even intend once they know more about the case.
Well, what you're describing, right, is rehabilitation.
Yeah.
And I do think that, presiding judges, trial judges have an incredible opportunity to rehabilitate prospective jurors where they may not fully understand.
Right.
Yeah, it's very well. All right, well, I think we all got our takeaways. It's my questionnaire and I'm focused on bias, so thank you for that clarity. All right, well, let's get to trial, because I think this is where the storytelling element in the case takes full bloom. Talk with us about, and share with us, if you would, an example or two where you've really seen in an IP case, an otherwise drab debate about the scope of a claim turned directly to a particular microprocessor architecture concept. And do you have any ideas? Maybe that's a high bar. We'll bring it down a notch. But, obviously a lot of the folks in this room, again, want to meet the jurors where they are, want to engage in something more than a dry technical debate. What are some things you've seen over the course of your trials on the bench, before you're on the bench, that have grabbed hold of the juries in ways maybe were surprising or simple but effective? They've been feeling this Tom, if you'd like to offer up.
I'll start. So one of the last jury trials I did before I took the bench was, it was a David and Goliath competitor fight, and we were representing David. And from day one, we started, was the privacy and recency issue. So we had our CEO on first, and it was a true immigrant story. Born in Asia, came to America, had this great idea to start a company based on remote controls, the team. And he knew nothing about the technology. He was not a technologist, but he was kind of a businessman, and he assembled a small team and again started in a little shack and built it into
Classic tale.
Yeah, the classic tale. And he told a very compelling story. And there were really, really bad facts in the documents from the other side. And the trial judge in that case allowed the equitable defenses to be presented to the jury for an advisory board. And that allowed me as lead to completely tell both the white hat story for our client and the black hat story, all the terrible things that the patent owner had done. And their motivations for bringing the suit and some really, really terrible emails that they've written. That story, and then we told the story at the beginning with the CEO, and then we did the technical stuff, and then our damages person at the end, because damages has so much to do with the business, echoed a lot of the same things, right? And so we bookended the trial that way and then closed it, right? And so that was how we told the story, and again, we think we won, but we won, so it wasn't that bad.
Well, I might have been the day you decided you were gonna go on the bench, because what more could you do?
Right.
But there's so much to unpack in what you described. I'd love to dig in a little bit and invite others to weigh in as well. You mentioned that you told the story through the CEO. Was that a given, just given the nature of that particular narrative or history, or did you have choices to make, or was there some trade-off you were weighing?
There was a trade-off. So he had a very strong personality, as a lot of kind of entrepreneur
To know to happen.
people do. And so there were, questions about how he'd do on cross and whether he could keep his temper and all that. But he was great. And so, a lot of prep and all that. But we did have choices, and we had to, because there were other high-level business people in the company who had been around a long time, could tell a lot of the same story, but they weren't founders, right? Yeah, so there was a definite choice we made there. And I will say the trial was not here up here. And so we had to make a decision, because the founder was agent, right? We had to make a decision about who was going to be the face and the spokesperson for the company, given the demographics and all that. And so it was, something to think about. There were some, very hard decisions.
Sound like you have the right.
It worked out, yeah, because success had a lot.
You mentioned also that your damages expert echoed and reinforced some of the themes that were first presented by the CEO. And last year, when Keel had bringing the way in. Is that the kind of, in record, we only have a few of that in Bill Pound's experience, but is that the kind of thing where on a downward emotion or as part of somebody's judgment or emotion eliminate, you might attempt to cabin or limit what the damage expert could do, given that they're not really weighing in specifically on how much and, in what form, but really just, presenting a broader part of the trial story. In other words, would you have concerns about a damage expert?
So there's always the concern that too much of the origin story is being told to the jury and just to play on their sympathies. And so, yes, we have to be careful on that. Sometimes there's something damaging that against the one side that is just, it becomes the theme of the whole trial. And, I do worry that at the end of the day, because I've let it come in, but I didn't know how it was going to dominate the trial, that in fact, I've got a 403 problem ultimately, that too much has come in, it's biased the jury, and their decision was based on their emotion about the case and not on the evidence. So it is something we have to be aware of.
Just what do you think? Is there a potential issue there?
There is, and it's very much as Judge Freeman described, and I'm speaking more from my practice before I came on the bench, but I think that damages, of course, can be painful for the jury. So it's, as a practitioner, I'd like to have some story to go with that. And you need it, you need that teaspoon of sugar to get those numbers down. And I'd like to think that I don't see a good way to manage that at the Daubert or summary judgment stage. I think it's an in-trial call, and at some point, and I've done this in proceedings before me, it's sometimes we reach the point of cumulative, and that can be a helpful tool.
It's also challenging, isn't it, that it's a Georgia Pacific factor for everything, right?
If you can't find a Georgia Pacific factor for your story.
You've got some challenges. Well, let's stick with trial for just another minute or so. In terms of trial order, like, do you ever weigh in, or have you ever seen other judges weigh in practice on sort of order of witnesses in order to accomplish that narrative? Like, how firm a hand are you in the exercise?
So I've never done that.
Yeah.
I mean, one of the problems is how little information the judge actually has about your trial. And so when we get motions in limine, you're trying to pre-try the case and keep things out. And often we don't have a good enough grasp on how they're gonna be offered in trial. And so, I mean, I limit my motions in limine to 5 per side. And I know you probably go to some courts where there's no limit and you're thinking of everything you can. There could be 30, 40, 50 of them. And I do this because I don't want another summary judgment motion. That's what many of them turn into. And I just need to be sure that they're not pre-trying the case. And sometimes the remedy that lawyers are looking for in these motions in limine, rather than excluding a piece of evidence, they want to exclude an entire theory of the case. And again, that's summary judgment. So we have to be, as judges, it's our job to be a gatekeeper and not let the motions in limine go too far.
Another way that I've seen judges attempt to structure the presentation to enhance the storytelling impact on the jury is by sequencing experts, often referred to as hot tubbing the experts.
So, yeah.
Back to that, that sort of come in and out of fashion, back in and out again, as far as I can tell, in the Northern District. Any of you have any experiences with, like, you know, sequencing experts in that way?
So
Or
the hardest thing is that the experts aren't necessarily available on the schedule we want. They're hard to schedule anyway, the practical part of it. But I find that a plaintiff team wants to put on their case the way they have conceived it. And they don't want the defense being able to interfere in, well, let me put my witness in between your two. It might make a better story for the jury, but our system is such that the plaintiff and then the defendant, and I see real pushback on anything about the defense putting in evidence out of order.
True. Nikki, have you ever seen hot tubbing of experts or some unorthodox side by side as clear presentation work in any of your cases?
I think for the themes and the arguments that we want to make sure that we sort of deliver and get those arguments across from multiple witnesses. And so usually we'll have a couple of, engineers or technical experts testify, and they'll testify to the facts as to why our product is designed in a specific way and doesn't infringe. You then will need your expert to kind of shore up that argument. I think the expert I usually view your technical and damages expert as like folks who can make essentially closing your case without the argument and without whatever they say is essentially evidence in the case. Whereas, the judge will instruct the jury that opening and closing are not evidence in the case. And so I think if you have a good expert who can really like pull it all together, who can really present it to the jury in a way, and they get to actually instruct and tell the jury how to rule on the ultimate factual and legal issue. I think having a strong expert presentation at the end of your case, where they pull it all together, and you can shore up, the factual testimony that your technical witnesses have provided could be very helpful.
And of course, the time limits are the big enemy.
Absolutely.
And so this build up with all of your company witnesses, and then you build up to your experts, and they get to spend time with the jury. If in some courts you get 10 hours per side, and so it's just a race, and you just talk fast and mind your words.
What is your current thinking of time limit
So
for that typical?
So for my typical patent case, it's 15 hours per side. So it's a 2-week trial, 2 weeks of evidence for the jury. And boy, that's a lot for a jury to sit through, but that's my rule of thumb. Is I always say, Judge Gilstrap made me look good because he does the 10 hours. So it seems like they've got lots of time.
Positively luxurious.
That's
Yeah.
right, that's right.
I seem to recall in your earliest patent trials, you adopted the time limit model and you stuck with it.
I have always done it, yes. And boy, I mean, I know I usually tell lawyers at the final pretrial conference, you'll be giving your closing argument on this day. Because I've run the hours and I know I start promptly and I know I end promptly at the end of the day. I've done enough of these that I know exactly the pace of the case. And it's rare once you're in trial that something goes really wrong that you have to shut down. It does happen, but, the jury deserves the certainty of how long they're gonna be there. And so I really pay attention to that.
That's why you're the favorite.
So I did a jury trial a number of years ago where at the final pretrial conference, the judge was very clear. From our side, was very clear that your chess box starts the moment the jury is picked. Right, and then you start taking time. The other side, you got, and like most judges, he made the parties keep track of their time and only come to him if there was a dispute. Blah, blah, blah. And, we've got about more than halfway through trial. And, and then finally our paralegals talk to each other just to check each other's clocks. About halfway, we figured that's the right time. And they were off. They thought they had like an extra 2 hours. Because they thought that the judge's rule was the chess box starts when the first witness takes the stand. Right, and so they had not taken into account a very, very long opening statement that or trial counsel had done, and even the little pre-trial talking welfare. And as a result, they did not put on a rebuttal expert on invalidity. And they had to cut short a whole bunch of, and their closing was like lightning fast, because they ran out of time. They literally ran out of time. So the tip is make sure you know exactly when the chess box stops and starts, and keep and check maybe more often on the other side to make sure that you're.
So I think it's the judge's responsibility to make sure that those details of the trial are abundantly clear. And I put out an order right after my pretrial that just goes through the dates and times. And I exclude opening statement and closing argument from my testimony. So that part's good, but it does include, if you're arguing a sidebar motion, the clock is running. But they know all of that. I go through it. I do put limits on opening and closing, but it's outside of my 15 hours. And lawyers are pretty reasonable about what time you need for your opening and closing. I think closing argument is the most important part of the case. I think it's just so important to help that jury that I'm generous on how much time I give.
Yes, it's a really, really important point. Well, we have a few minutes left. I want to give folks in the audience a chance to ask a question or two or three. So why don't we take questions? Yes.
Hi, everyone. Thank you for being here today. What are your thoughts on adjusting the time limit for a case that has a significant amount of additional patents relative to your average case?
So I'm sorry, I have a hard time hearing. Time for adjusting.
If you have a patent case that has a significant amount more patents than your average case.
So a 1 patent case is going to get less time than an 8 patent case, there's no question. So I do a number of things though. Those unwieldy cases with 5 or 6 patents that are still there for trial are a problem. So I start at my 15 hours and then I look to see what we can do. But throughout the case, from my initial case management conference all the way to summary judgment, I make the lawyers reduce the number of asserted claims and the number of prior art references. And so it becomes more manageable. I don't make them delete patents, but just to get the junk out of the case. And I usually let them set the numbers. But then ultimately what I do, and that's unlike some other judges, I look at the case, I give them the time I think a jury can devote to it. And I say to them, you can present as many claims as you want, but here are your 15 hours. So either talk fast or throw some of them out. And it's just a decision. I know other judges in other parts of the country limit the number of claims.
Absolutely.
And I don't. I do have this funneling, but it's really a prod and not a requirement. And I don't want to do summary judgment on the junk is really why I do it. Because they'll throw everything against the wall at summary judgment, make me work on it, even though it's not going to trial. They wouldn't.
You've got a prod, but maybe not an electric.
That's right, that's right.
Who else has a question? And thank you all for being here. What are your thoughts on an attorney giving milestones or context, introducing each witness to fit into the overall story?
I do it, I mean, I like to be able to do it, as a practitioner, and again, in a really complicated technical story, I think it's helpful to the jury, but you gotta keep it on the short page. You know, it can't be extra arguments. And usually, you know, the witness, I would say an expert witness will lay out their own to their, you know, their headings. So I think that was really.
Yeah, I think it's a good idea. I mean, if my cases go so fast, in 2 weeks, you don't really need to do that, but I think it's really important for the jury.
Could not agree more. Questions over here? I think we saw a couple. Oh, okay, who's taken over here?
On the storytelling piece of this, how much about the story is the words that you're using and how much about it is the presentation that you bring to it?
Well, it's hard to separate them. You know, it's really interesting. The jury is, you know this from your jury consultants. They're looking at everything in the courtroom. They're looking at how you're dressed. They're looking at how you're sitting in the chair. I mean, you know, any of you who has tried a case, either with Fish and Richardson or against them, Juanita Brooks and her team, black shirt, black suit, that's it. She probably has 20 black suits in her closet, but that's it. It's a uniform. She draws no attention to her clothing. And what I find in trials with her is all the women lawyers start wearing black suits by the end of the trial, because it's a very subtle point. So it's all of those things in communicating with the jury and eliminating the distractions. So a lawyer who is telling a great story, but is stressed for whatever reason, we're all stressed, but shows that anger toward their own staff, that's a loser. I once had a trial years ago where this brilliant, accomplished senior partner at a great firm was so negative toward his own staff when they weren't instant in getting his demonstratives up, that the jury hated him. And the plaintiff representing the patent owner was the most likable person. My law clerks used to say, I'd like him for my friend, as a trial lawyer, because he can convey that so easily. So it's everything about your presentation that matters. It's everything.
Time for one more, maybe? Back, yeah.
It's always great to learn from good examples. Would you have transcripts or cases that you would suggest that people read either for a very good opening, very good closing, or very good storytelling in a technical context?
Any particular example of a case in your 10 years, the second 10 years that stands out in your mind is a great illustration of how to tell a good story.
You want to read the transcript of a patent case?
So I would say, you know, we don't get a lot of pharma cases here in the Northern District. They tell a great story. They tell a story sometimes that can bring you to tears because of the transformative nature of the invention. And I think you can learn from those stories. I think that the closing arguments that deal with, you know, as Judge Kong says, the immigrant founder who started from nothing and created a company. Those are the stories that we remember. And it's, you know, I had the real privilege of presiding over one of the cases between Gilead and Merck over the hepatitis C drugs. So they, you know, that drug saved millions of lives worldwide. It was transformative. And the story was, and then those scientists came into court. I mean, you can't, I was on the edge of my seat the whole time. I think the jury was too. It was so compelling. I know a software case and all the technical, it's hard to tell that story, but still finding the parts of your story that will resonate with people's everyday experiences, I think are what's out.
But wait, the architecture is different, the client and the server.
Well, every patent is an invention that we didn't have before, every one of them. So every patent tells a story that this is new and this invention was important to this industry. So every one of them does. I mean, you know, it's.
Maybe not the invalid ones, but.
Well, the jury's not, yeah.
That's fair. Well, we're gonna bring things to a close. here. I just want to remind everybody, we have a reception downstairs. I want to invite you to join us downstairs for the reception. Please turn in your name tags. You can do that in the reception lounge downstairs. I've got that right. And with that, I think we're adjourned. Thank you, Nikki. Thank you, judges. Wonderful.
Pleasure.